Why don't we just launch right in, and we're going to start in the area of copyright, which is also always a very fertile ground for litigation. And Milt, we've got a couple of cases that you were going to start us off with in the copyright infringement area.
Sure. We have Price versus Fox Entertainment Group. This is the dodgeball case. If any of you have kids, and I have 4 sons, you get to see this movie a lot. This is the Ben Stiller movie involving an underdog sports team, dodgeball team that enters a national tournament. The screenwriters in this case brought a copyright infringement action against Fox, alleging that essentially their manuscript was stolen. The court in this case granted summary judgment in favor of the plaintiffs, the screenwriters. What the court found was both works are superficial, fast-moving comedies, spoofing underdog sports films. Each work told the story of a group of misfits led by a main character who forms an underdog dodgeball team pitted against a stronger rival team of bullies. In each work, the underdog team decided to enter the national dodgeball tournament that awarded prize money, which the team needed to save a business in distress. And in addition, the court found that several characters that appear in both the defendant's version of the film or in the earlier drafts that the defendants did share the names and certain characteristics of the characters in the plaintiff's work. The court also found that because the defendants, there was an issue, it seemed that the defendants had access to the plaintiff's manuscript as a result of knowing someone at the William Morris Agency. They also factored that into their analysis, and they found it in favor of the plaintiffs. That's the dodgeball case.
And then we have another one here that's, and these are one of these cases where, you know, courts will often say, and we also talk about summary judgment, historically was not supposed to be easy to get in copyright infringement cases, but we have one, we see it more and more in copyright infringement cases, summary judgment without a trial, and we have one of those right here in the Slice of Pie Productions case.
Yeah, this is the second case, and again, if you have 4 sons, you get to see this movie a lot. This is probably why I volunteered for these particular 2 cases. Anyway, the Slice of Pie is the White Chicks film with the Wayans brothers, who, if anyone remembers In Living Color, you're very familiar with the Wayans brothers. In this case, the court, it was brought in the District of Connecticut, it was decided in 2007, and the court granted summary judgment on behalf of the defendants. In this case, it was the Wayans. The screenwriters who brought the action had a screenplay about an African-American FBI agent who disguised himself as a white Italian-American to infiltrate the mafia. Anyone who's familiar with the White Chicks film knows that the Wayans brothers, who are African-American, disguised themselves as 2 very socialite and very well-to-do white women who were in their, I think, early 20s, and were hanging out in the Hamptons to crack a ring out there. And I forget exactly what the crime that was going on was, but the court found that based on the concept, the theme, the characters, the sequence, pace, and the setting of each film, and they found no substantial similarities. In addition, there was evidence that came out during discovery that the Wayans had been contacted by the Slice of Pie Productions individuals on several times and had turned them down over and over again, saying, no, this is not the kind of angle we want to take. And obviously, the White Chicks film was different. So this is an instance where summary judgment was granted on behalf of the defendants in a copyright infringement matter. Okay.
Now, another key issue in this case, and also one that the defendants won on, is the claim of breach of implied contract. Because here, as Milt was saying, there was no promise, there was no bilateral expectation of compensation. So the plaintiff's claim for implied in fact contract did not prevail. But I just want to quickly update you on a major case in that area out of California, Grasso v. Miramax Films. And that is one where in 2004, the Ninth Circuit said that the implied in fact contract claim was not preempted by federal copyright law because it had an extra element to it. And that was remanded back to the state trial court. Well, there, just recently, the California Court of Appeal, it looks like near the end of that case, has said that there was no implied in fact contract in that case, because of the fact pattern where you have somebody who's basically sending out, reading Writer's Market and sending out a screenplay. This was based on, I wrote a screenplay and you did my movie, you did your movie based on my screenplay. Let me just quickly give you the site for that so you'll have it. This is, again, implied in fact contract dismissed, as in the Slice of Pie Productions case. This is Grosso, Grosso, v. Miramax Film Corps. It's B193872.